Each side will have 15 minutes and the appellant may reserve up to 5. You may proceed.
May I step forward, Your
Yes,
Honor?
please.
Thank you.
I apologize, the acoustics in here are not as good as we'd like them to be, so.
I'm sure you'll be
Members
able to
speak
hear
up.
me. I've never had that problem. As I was preparing, we had one of the hottest weekends, I think, in a long time. May it please the court, judges, Attorney Hall, and parties, my client Rebecca Sanderson. As I was preparing, we had this nice hot weekend, and I noticed that they were testing the water in the pool, and if it doesn't test right, we get everybody out of the pool, and we make them stay out of the pool until things are okay, and then we let them back in the pool usually. But in this case, Ms. Sanderson hasn't been allowed to actively parent and get back in the pool. And I think it's wrong, and I think there's a constitutional right that's being violated here. And I think that we have some good case law that would support what my arguments are, and I think it was well thought out with respect to opposing counsel, but I don't think the grandparents have the right over the mother with this child. Ms. Sanderson was in an abusive relationship that's in the transcript, and she goes into detail in the transcript with the father of this child. She has survived getting out of that relationship with that person. And not only did she work for the Portage Regional Authority, but we trust her to drive a bus every day with valued members of society on that bus. And she works now for the Cuyahoga County Greater Regional Transit Authority, and she has moved herself up to a 26-plus hour job. You know, the ability to really earn and to be able to support her child. One of my biggest assignments of error, as you will notice in this case, is that the psychologist said that any report prior to his would be stale. This is Dr. Colin Myers. And it's at the very beginning of the transcript in the very first book. He states in his testimony, I'll just summarize for you. He states in his testimony that she is able to parent. There would be no reason. He would have no reservation about her parenting. And he talks about the different aspects. And one of the aspects that came up is she did serve in the military, and there was an issue, and he said that some of the affect could be from that position, or that she could even suffer from some PTSD, but she was being treated. The psychologist did not testify that treats her, and the guardian ad litem makes reference to a psychologist, but we never see the report or have the paper to say that she can't parent or anything like that. So there was nothing really investigated by the guardian that was new. It was same old, same old. Children's Services is not a party in this case, but they made the determination that she should do a program that infants weren't allowed to do. And by the time Ms. Sanderson got to them and said, they won't let me in this program with an infant, her case was closed. And then she suffered with the tremendous strain of the financial resources necessary to come to this court, or to come to any court. And she has worked hard to achieve being able to pay me. I am paid by her. And she has worked hard to try and put together housing, and she did that. The guardian never even saw her residence. The guardian never really talked to her about the situation, never really knew her. And the guardian admits in the transcript that she really didn't evaluate it that much to know the answers to some of the questions that were posed to her, either by Connie Hightower, who was representing Rebecca's mother, who also filed a custody action, is not part of the appeal, but it's all in the transcripts. And the reason that was done is because she felt that they never even talked to her Children's Services to see if she could be a parent to this child when the problems began. Rebecca makes clear in the transcript that things were not good. The water wasn't good in the pool, you might say. Things were not good, but if you test it again, and people deserve a second chance, McBride's my favorite case here, because they say, you know, there is that smile of hope. And this is this child's mother, and this is a very young child. But the most appalling things that happen in the transcript in this case, to me, is that the Clevelands don't cooperate with giving Rebecca visitation. They make up rules as they go, as the testimony will show. And the saddest part about the case is that she went to take a picture of the child and they said there's rules that you can't take a picture. Whose rule is that? I couldn't find it anywhere in Summit County rules that a mother can't take a picture of her child. So a lot has happened to Ms. Sanderson in this case that really isn't fair, and maybe Ms. Sanderson is at fault for not getting into court fast enough, but it's really hard for these people without money. After hearing her case, I hear maybe 15 cases a week like hers. Every now and then I do reduce my retainers so they can afford my services or anyone's services. And in her case, I did reduce even my hourly rate for her to make it, and she has made good on her payments. She's also paid Dr. Myers, so she's showing real effort here in not only establishing housing, but in paying the bills to get this child back. She has suffered immensely. But as the mother, I think she's entitled to the bedrock right of having the best interest of her child be seen by this court. And she desperately needs this court to really look hard at her case.
You mentioned best interest, although clearly your argument is focused on the mother's right, but what we're compelled to look at as the lower court was is the best interest of the child. Perhaps you could speak to that.
I would love to, Your Honor. The best interest of the child would be that he be with his mother, who gave birth to him, loves him immensely, and would be with the person who truly wants to parent him, and he will always wonder where his mother is. The other issue is that the Clevelands do not do what's in the best interest of the child. There's been a ton of moving around, a lot of child care time, not seeing family members. Her family is not seeing the child very much at all, and they were even willing to be parents in Ohio, where this child moved to Texas. It is not in the best interest of this child that he doesn't see the mother on scheduled visitations. It is not in the best interest of this child that he be controlled by Mr. Cleveland, whose son was the one at the heart of the abuse of Ms. Sanderson, and now controls Rebecca through the visits. It is not good that he doesn't know his mother. It's not good that he moved to Texas without permission of the Summit County Juvenile Court. It is not in the best interest to have the child with someone who doesn't follow the orders, as pointed out throughout the transcript. Mr. Cleveland interferes with the ability, and Ms. Cleveland actually, with the ability, according to Rebecca's testimony, of being able to see the child. And then they just cut visits short. There was one that was scheduled for so much time, as it's pointed out in the transcript, and then all of a sudden it's hardly any visitation. It's in the best interest that the mother be able to parent if she can parent. Second chances also in further case law that we've pointed out, second chances are granted to people. She has not had a second chance with this child. Nor has she had any chance really to do her parent plan with Children's Services. And when they told her that the program doesn't go with an infant, she should have been allowed to do that.
Given that the trial court acknowledged that there was a change in circumstance sufficient to review the matter, what are we to do with the fact that a move was anticipated at the time the child was placed in the custody of the grandparents? I understand that it's not the same move that occurred, but what are we to do with that information?
Thank you for understanding that it wasn't the same move. With that information, there would be moves potentially, but I think that the court never thought that this child would be with them that long. This was a temporary thing. The other thing is I think Children's Services failed miserably to interview all the potential candidates that could have been out there. Mainly, her mother, who is right here in Summit County, could have stepped in and was never even vetted, you might say. It's a popular word this week, but the vetting was never even done of that potential candidate. And I really feel that the stale report that the guardian ad litem relied on in this case is not in the best interest of the child. It's not in the best interest. Everyone should be with their mom if it's possible, or their dad. And the report on the dad is that, which I wasn't even allowed to, he supposedly filed a report with the court. We have no way to have him testify because he didn't show up, to say that he's not interested in parenting. We don't know that. We don't even know that he filed the paper. He didn't answer anything that we sent him throughout the case, so we don't even know that the father actually wrote that. We had no way to have any testimony that the father didn't want anything to do with parenting the child.
Counsel, I'm gonna interrupt you because you are just a little less than 5 minutes. Did you really retain?
I would like to save the rebuttal, and thank you for interrupting.
No problem. Thank you.
Will this bother you? This is here. I can, thanks.
Good morning, you may proceed.
Good morning, thank you. May it please the court, counsel, authorities. I appreciate Mother's concern and her point of view. Her issue, however, is with the law, and the law, unfortunately for her, is clear. We had something of a mishmash of the law in Ohio until 1989. And at that time, in response to cases that lingered on and dragged on and did not result in clear child custody determination, Senate Bill 89 was passed, and that sort of put a 2-year time limit on how long juvenile court through dependency, neglect, and abuse action could get involved. A number of years later, the various case law interpretations of issues of permanency, permanent custody, what constituted reasonable efforts on the part of the agency, were recodified in a new bill which simply took those court judicial findings and incorporated them into the new statutes, sort of cut to the chase. As a result of which, this court and the Supreme Court have been very firm in looking at the legislative intent that a year means a year. You have an opportunity to move forward. If you can't quite get everything done in a year, we can extend it 6 months. If you're still very close, but perhaps we're not comfortable that your housing is stable, we can extend it another 6 months. But in order to get that extension of time, a parent must have substantially complied with the case plan and virtually remedied the issues which caused the child to be placed in care in the first place. In this case, the underlying dependency and neglect action, we came to the 1-year mark. Neither parent had done much to speak of on the case plan. The child had been placed with the paternal grandparents all along, and over no objection, over no significant objection, the child was placed into the legal custody of his grandparents. It is incorrect, to say the least, to suggest that this was never seen as anything permanent. It was seen always as something permanent. And in that underlying case, the grandparents discussed they would be required to move. He works for the Veterans Administration, she for the GSA. And they were able, through Family Leave Act applications and whatnot, and telecommuting, to work out staying in Akron for a little over a year to parent this kid. But at that time, the expectation was they would return to Virginia, which was whence they'd come, and would resume their jobs there. You might remember there was a little fluff up about the Veterans Administration and the hospitals in the Southwest, so he didn't get to go back to Washington. He had to head over there, and his choice was Arizona or Texas. And Texas was closer to Ohio, so he chose Texas. They attempted, without counsel, to color inside the lines and file the notice of an intent to move. They didn't get mom properly served. Their son signed off on it. And as a result of that move, mother came back to court and said, that's all fine and well, but I want my kid back. It is established under the United States Constitution that raising your child is a fundamental right. And through a variety of cases, the Supremes have outlined what it is we need to see to ensure that a parent's constitutional right to raise his child is protected at the same time the child's right to appropriate parenting is protected. And how we've applied that scheme in Ohio is what we've said is we're going to take your kid, probable cause to take your kid. We're going to have a trial with the rules of evidence at the adjudication, at which point it must be proved by clear and convincing evidence that your home is insufficient for this child, whether that's by dependency or neglect or an abuse. Your home is insufficient, your behavior is insufficient, you can't have your child at this time. Then at disposition, the proposed case plan by Child Protective Services is presented to the court that in effect says, if the parent will do all these things that will fix the problem, the kid can go home. And the expectation is that that will happen within 11 months, because if you want to extend things longer than that, you have to be filing magic paperwork at the 11th month. That didn't happen in this case. The police took 6 or 8 months to determine whether or not to charge either parent with the bruising that called the child to the system's attention. They did not believe that there was probable cause to arrest or indict either parent. They had their suspicions of the causation, but that's not enough to go on, and I'm not going to share those with the court because that's not part of the proceedings and it serves no purpose. At any rate, so then the Ohio Supreme Court, in a decision that really eviscerates Mother's case, is in re CR, which addresses the concepts of a change of custody and when can a child be returned to the parent. And what that case said is, because these are not permanency proceedings with regard to the parent-child relationship, parents always have an opportunity to come in to see their kid. Fact of the matter is, when parents split up, the kid's only going to be living with one parent some of the time. We've got an awful lot of ex-parents in our country who see their children not on a full-time basis. And that is sort of how in re CR was treating the child protective stuff, saying this isn't a permanent removal. But the legislature was very clear. Once we change custody, we intend for that to be permanent. And the only way it changes is if there is a change of circumstances in the home of the child, effectively. Well, there was a change of circumstances, but it was contemplated at the time the original order went on.
Well, once the trial court acknowledged there was a change of circumstances, who has what burden at that point?
At that burden, the moving party, at that point, the burden is on the moving party who already has to have shown there is a change of circumstances to then show two things: that changing the residence of the child is in his best interests, and that change will not harm the child more than the benefit done to the child by the change. And I chose not, it was tactical, I chose not to challenge the court's finding of a change of circumstances. And like I say, in part it was tactical, in part I'm not sure that it's an argument that Mother needs to hear. Let's get to the meat of the case, and the meat of the case is it in this child's best interest to be removed from the grandparents where he has spent his entire life and replaced with his mother? And the answer to that is no. Yeah, there was no change in Mother during the year that the CSB case was open, and there's been no demonstrated change since, except that some guy came in and said, oh, all this stuff that ever happened before doesn't count anymore, and she's fine because she drives a bus. And that's pretty much the evidence that was before the court. No one doubts that she would like to have the child. No one doubts that she wants to see her child. She has, her mother has. They Skyped frequently, but unfortunately, the family that this child ended up with was required to move to Texas instead of Virginia. So the court made, I think, fairly sensible rules concerning what visitation would need to occur now. And of course, as the child gets older, his ability to come here for a summer and stay with his mom increases, but he is still of tender years, so that's not appropriate at this time.
To But I thought I read in the brief that the trial court made some financial adjustment with respect to mothers' support responsibility to take in consideration the expense that she would have to make in visitation.
It did, and it made the finding that asking her to pay any additional support would be unfair. So she is relieved of the support, of an ongoing support obligation, because she is going to be taking on the burden and expense of traveling to see the child. And so the court didn't want to punish her. So it did make that adjustment, and found that that adjustment was in the best interest of the child, because that way mother could see him, and the trial court acknowledged that visitation with the mother is important. So I feel for mom. I'm not personally satisfied with the way our law works with regard to this. It makes me uncomfortable. I don't think it's fair. The United States Supreme Court and the Ohio Supreme Court and this court have all upheld the statutory scheme we have that addresses issues of custody. So I do not believe that there is any straight-faced constitutional claim that can be made. The question is simply, was the law followed in this case? And unfortunately for mother, it was followed in this case. The court took all of the evidence she could submit concerning what would be in the child's best interests, and it determined that the child should remain where he is, that is in his best interest. So from an abuse of discretion standpoint, it was a very well thought out, well-written magistrate's opinion, which was then adopted and modified in its language to a mild extent by the trial court. So we actually also have evidence that the trial court undertook an independent review and didn't simply sign off on what the magistrate did. And she was satisfied as well. So at this point, we're really looking for an abuse of discretion against the trial judge. And I don't believe that the transcript or the transcript of the trial proceedings or the docket reflect anything that rises to a level of capriciousness or abuse of discretion. And that is all I have, unless you have anything for me.
I don't believe so, thank you.
Thank you, Your Honor.
You have about 4.5 minutes.
Thank you. As we have discussed here, we talked a little bit about the children's services issue. The judge did allow Rebecca to testify in the proceeding about that, where she does testify that they gave her a plan that an infant you couldn't do if you had an infant. By the time she went to Children's Services, literally they just closed her file. She couldn't do the plan. They wouldn't let her in the program that they gave her. So clearly, that's just absolutely not even possible to do.
The only issue I'm thinking in regard to that, those are the kind of things that I feel like should have gone into a determination whether legal custody was in the best interest with the grandparents, not at this point. It seems like it's a little too late.
Well, that part is too late, but it's the best we can do with it right now, because it's when she was able to obtain legal counsel. The other thing is that the guardian ad litem, she testifies, never talked to her in the first case. She never even knew who that guardian ad litem was. Then in this case, the guardian ad litem does not look at her property, does not look at the Texas property, does not, and relies on an old psychological report, does not take in Dr. Meyer's report into consideration at all. And she says that she hasn't explored it. And so, you know, she's really a victim of the situation, and she's entitled to that total constitutional right to be able to parent her child. And she can parent her child. She's worked really, really hard, and she's entitled to that, to be able to be this child's active parent. She is the parent. But to be the active parent is really important. And I think that McBride sums up the case, and I'll leave you with that today, which is that the overriding principle in custody cases between a parent and a non-parent is the natural parent's have a fundamental liberty interest in the care, custody, and management of their children. Also in McBride, they talk about, in paragraph 14, I believe it is, in McBride, that paragraph really sums it up, that she's entitled to that smile of hope. And, you know, if we never give a child back to a parent that has had troubles, there'd be no hope for any parent that's in that system. And I'd love to say that Children's Services organizes everything really well, and at times they do. But at times, this is the catch-all here that we're seeing today. And it is with pain that I bring this to your attention for her, you know, that it's not easy, the whole case. And I think that, you know, clients do wear out, and it shows their lack of devotion to what they're trying to achieve in court. They do wear out in this system real easily. She is not worn out. She's been steadfast. And she has done everything I've asked her to do, which I think is really a big step of showing that she's ready and willing to parent. And I think she's also willing to do any parenting class any judge would order her to do. And maybe that's, you know, the remedial part of this, you know, that maybe somebody could order her just to go through a case plan that's given appropriately. When you go to the case plan place and they tell you, oh, sorry, you can't be in this program because you have an infant, surely we have to fix that. She comes from a good family. There's lots of siblings that aren't seeing this child. And more importantly, he has 2 siblings of his own right here, this little child. So there's 3 children, you know, that she has. And the other 2 children are here. She parents with the other parent, and is able to see them, but Gabrielle is not seeing his brothers. And that is really poignant, and I think we didn't bring that up earlier, that's important as well. But I do believe that McBride says it best. Colin Myers said that the report could not be relied on, the old one, because it's more than 12 months old. And it's a qualified psychologist. He has 30 years experience. It wasn't like he really took a chance too of having to get paid on this case, which I was surprised about, because rarely do I see a doctor come in and take payments, and he did, and she paid him. I think she owes him $100 at this point on the whole bill. And you know, it's not cheap to do that. And he said that you cannot rely on the old report. It's against the rules of those types of reports. And I thank you for your time. Thank you for your thoughts and your decision.
Thank you, counsel. The court will take the matter under advisement and issue a written opinion that will be sent to both sides. We will also release on our website and the Supreme Court website electronically. So you will be hearing from us, and you can check the websites too.
Thank you, Your Honors.